University System of Maryland's Wills and More Week in recognition of the National Estate Planning Awareness Week. My name is Ann Kolakowski. I'm Director of Gift Planning Services at the University System of Maryland. We're delighted that you've committed yourself to learning about this important topic and hope you'll be with us for as many sessions as possible. Before we begin today's program, I want to share a few housekeeping items. Our session will be recorded and links to all recordings of the week sessions will be sent after the week is over, together with a short survey to help us plan for next year. If you didn't register for other sessions, but you'd like to attend one or more of them, simply join us at noon each day by using the link sent in the email that contained the link for today. It's not necessary to register again. If you have questions as you go along, please put them in the Q&A box and keep them general in nature. We'll answer as many as time permits. You can upvote questions you like to move them to the top of the queue. And lastly, all of this week's presentations are being offered for informational purposes only, and the content should not be considered a substitute for advice from legal, tax, or financial professionals. And it is now my pleasure to introduce one of my system colleagues, Janine Callahan, who is Director of Planned Giving at Towson University. Welcome, Janine. And I think you're on mute. Well, we're having a little difficulty at the moment. I'm going to go ahead and introduce today's speaker, and Janine will be with us for the Q&A. So today's speaker is Christopher B. Walter, and he leads Davis, Agnor, Rappaport, and Skulny LLC's estate planning practice group with a blend of expertise and strategic planning. Prior to his current role, Chris spent 6 years at a boutique estates and trust firm in Baltimore County. He received his BA from University of Maryland College Park and his JD from the University of Maryland Francis King Carey School of Law. So he is a double system graduate. A longtime resident of Howard County, Chris is proud to serve his community and holds volunteer leadership roles with several nonprofit organizations. He spends as much of his free time as he can with his family and friends, something we all find a worthy goal. Welcome, Chris, and thank you so much for donating your time today to share the basics of estate planning with our audience.
Thank you so much, Anne, and thank you everybody for joining. I'm glad to be taking a little bit of time to help spread the good word. So, yep, that's, I guess, my intro and a little bit of background about me. So I'll move right into the presentation. All right, so in this presentation, we're going to go over what is estate planning, how do I make an estate plan, and then what are some considerations when going through estate planning. So we'll start with what is estate planning. And it's really planning for two things. It's planning for disability and then planning for death. We do this with a series of documents. With planning for disability, it's normally powers of attorney, advanced medical directives, and then if you don't have those documents in place, you're kind of left to the guardianship process. In some states, it's called conservatorship, but that's the substitute for doing the planning. Planning for death, it's often done with a last will and testament. Sometimes it's a revocable trust. We'll also talk a little bit about other types of irrevocable trusts. And then beneficiary designations or titling of your assets can also control how things flow. So we're going to start off talking about planning for disability. And the first thing to talk about is who can actually make legal and financial decisions for a disabled person. Well, the guardian of the person or the property can, an agent under an advanced medical directive, or an attorney in fact under a power of attorney. And that's it. I mean, there's some niche circumstances where somebody else can be a decision maker, but nobody else is automatically authorized. So not a spouse, not an adult child. So why do we do the planning? It's so you can designate who you want and not who the court decides to manage your affairs if you ever become disabled. So we're going to talk a little bit about guardianship, the alternative to doing this planning document. And it's to minimize that stress that all these processes end up causing on the family. So guardianship only happens when somebody becomes disabled. It's invasive, it's time consuming, it can get expensive, it requires accountings with the court. You have to account for every, penny in, penny out of the guardianship estate. It also relies on a priority list of who petitions the court, who comes forward and says, I want to be so and so's guardian. You don't get to necessarily pick who your guardian is. So we want to avoid that at all costs. And you can do that through a properly prepared advanced medical directive and power of attorney. We'll start off talking about the medical directive, and this is for the healthcare side of things. The medical directive, we use the term declarant as the person who makes the medical directive. It's for healthcare decisions when you can't make them for yourself. You're also going to express your end of life wishes, and you can authorize the person to make funeral arrangements. We've talked about guardianship. There are two types of guardianship of the person and guardianship of the property. The healthcare directive is more focused on avoiding guardianship of the person. It has three parts. There's part A, which provides the administrative powers to your agent. So it lets them do things like hire and fire doctors for you, or ride in the ambulance, or talk to doctors, consent to care, things of that nature. Part B is your instructions to your healthcare agent or the physicians at your end of life. So it's a terminal condition, an end stage condition, or a persistent vegetative state. There's no reasonable hope for my recovery. What are my instructions to the healthcare providers? And then part C can clarify your wishes for what happens to your body after you pass away. So are you an organ donor? Do you want to be buried, cremated? Some people get really detailed in this section. Some people just say, just whoever I've named as my agent, they can go ahead and make all the decisions for me. You might have heard of a MOLST, or medical orders for life-sustaining treatment. Different states have a different take on this form. This is the Maryland specific one. It's Maryland's DNR form. So this is a standard form. This goes in tandem with a medical directive. Technically, the medical directive trumps it, although when an EMT comes to the door, they're going to look on the fridge for this form, and this is the one they're going to follow. This is prepared by a physician and not a lawyer, but it really should match what a medical directive says. It's slightly different in that this is more, if I'm in cardiac arrest, do I want to be resuscitated? But there are some decisions that dovetail with each other in that part B, the end of life care. Part A of the medical directive, where you give your agent all their authorities, one of the authorities that's very common to list is the ability to fill out a MOLST on your behalf if you haven't filled one out yourself. So if you're not competent, you're about to go into surgery, and your agent wants to fill out a DNR, they can fill that out for you. But this is something you do with a doctor, not a lawyer. All right. Power of attorney. This is for legal and financial decisions instead of healthcare decisions. So we use the terms principal and agent. Sometimes we use the term attorney in fact. Maryland has a statutory power of attorney, meaning when we prepare it, we don't use well, for the most part, it's not a form that we have written. It's a form the state of Maryland writes. We supplement it with some other things that we think are really important to add, but for the most part, it's copy and paste from the code. We do that for a reason, and it's because when you use that Maryland statutory form, if a bank tries to reject it, well, your agent can sue them and can get that power of attorney enforced, and then the bank is supposed to pick up all those court costs and attorney's fees. So it's a pretty powerful statute to have to use that statutory form. And instead of guardian of the person, which is what the medical directive is trying to avoid, the power of attorney is here to avoid guardianship of the property. So this is the one where there's those supervised accountings and things of that nature. a little chart of who does what. The medical directive is medical decisions for the declarant as opposed to financial decisions for the principal. It gives access to manual. You can read the chart. I won't read off for you. All right. So that's planning for disability. The next section is planning for death. So how do we plan for what happens when you pass away? And what are the considerations? Well, first is providing for your spouse, your family, your loved ones, and charities. You can direct how your property passes instead of the defaults under the law. There are ways that you can pass along your assets that safeguards it from mismanagement of creditors uh, or the mismanagement of wayward benefits, maybe. There are tax considerations, of course, and then obviously administrative expenses and headaches. We want to keep those down to the extent we can. So before we get into the nitty gritty, I like to start out estate planning conversations, just framing it with how property actually passes at death. And there's four basic ways, and separated into these two big buckets. But way number one is jointly titled property. So if I own a bank account with somebody or a house with somebody, and it's titled together, and one of us passes away, it'll typically go straight to the other person. The second way are by beneficiary designations, and that's that contract property. So that's retirement accounts or life insurance, or if you put a TOD or a POD on a bank account, whatever it says in that contract is what goes. Third is property owned inside of a trust. If property's in a trust, the trust says when so and so dies, such and such happens. Well, those are the rules of the road. And then way number four is everything else. That's what goes through probate. And probate is either through your will or through intestacy. All right, so what is a will and why do you need one? And then is a trust right for you? What goes into a will? And by the way, I use the word intestacy. I'll go back and explain what that is in a second. We're going to get to that. So what goes into a will? So there's important administrative provisions. So there's things about funeral expenses and taxes and things like that. Waiver of bond, all that fun stuff. It directs what happens to your stuff after you pass away. It can establish trusts for beneficiaries, and it names those decision makers in your documents. It's your personal representative, which is what Maryland calls the executor. It can be guardians for minor children, which is really important, obviously. And then if you do establish trusts, it names trustees. When we're drafting a will or a trust, we have a bunch of things in our head, but some things to absolutely take into the conversation. You have special needs beneficiaries that are getting a means tested benefit. Do you have concerns about a child or another beneficiary getting their inheritance outright? Are they going to go and start making dangerous decisions with a dangerous amount of money? Is there something that you want to go to a specific person that's going to be directed to, I want the beach house to go to this one kid because they're the one that uses it, and my other kid moved to California and they never get out to the East Coast? Do you want to safeguard the possibility of in-laws or creditors getting access to your property? Is your family a blended family? Do you need to take some steps to make sure that, yeah, my spouse is going to benefit if they survive me, but at the end of the day, everything's going back to my kids? And there are a ton more things that need to be sort of checked off the list, but these are some of the things in the forefront of our mind when we're checking our boxes and looking through a family situation and evaluating what type of documents are appropriate. All right, going back to that intestacy word, what happens if you don't have a will? Well, the state of Maryland has written a will for you. That's what intestacy is. It's the default position, as it were, for where your property goes if you pass. There are a bunch of different scenarios. It mostly goes to where you'd expect it to, but there are not, there's some exceptions to that. And it may not always be where you want it to go or in the manner you want it to go. So by doing a will, you get control over where your assets are going, and you're also controlling who is administering your estate. Because just like in that guardianship statute where there's a pecking order of who can petition for guardianship, same thing with intestacy. So let's say um, you've got three kids and you don't have a will, and uh, you pass away. They all have equal footing to say I should be the personal representative, and that could cause quite a mess. All right, so probate. Use that word a couple times. What is it? It's just the process by which the courts make sure that the instructions in your will or that the laws of intestacy get carried out. It determines the validity of the will. It names the personal representative. So the court comes in and says, you, John Smith, are the personal representative of the estate of Nancy Smith. And the court supervises how everything passes from point A to point B. Who's doing the supervising? Well, I've said the courts, and sometimes it is the courts. Oftentimes, it's an administrative procedure by an office called the Register of Wills. And it's something that Maryland does pretty well, all things considered. Probate's not the big scary word here that it is in a lot of other states. But oftentimes, we will look to avoid it if we can. It's going to be situation dependent. All right, avoiding probate. There are a couple of different ways to avoid probate. One of the most common ways are revocable trusts. What is a revocable trust? You might have heard revocable living trust or a living trust. Different attorneys use different terms, but those are all kind of the same thing. It's essentially a will substitute. It is something that you make now. And if you think back to those four buckets of how things pass at death: joint titling, beneficiary designations, trusts, and then everything else. It's moving the everything else stuff out of bucket 4 into bucket 3. It's uh, it really has no tax benefits. It has no any other benefits aside from um, a management tool and avoiding probate. It's not protecting from creditors or anything like that. Also, it is a more private process. So the will, when you pass away and it is probated, it does go into the public record. Anybody can go down to the courthouse and get a copy of your will. Trusts are private. Only the beneficiaries see the will. I'm going to talk about the terms. The settlor, grantor, trustor, that's the person who creates a trust. Those terms are used interchangeably, and it depends on what lawyer is drafting it. But settlor and grantor are the terms that you see most often. Trustee is the person who runs the trust, who's in control of it, and beneficiary is the person who benefits from the trust. When you make a revocable trust, you are all three of those people. You're the person who makes your revocable trust. You're typically the person that runs it, and you're the person that benefits from it. So you're wearing all three hats. Yeah. So when are they useful? Privacy. You've got a disability imminent. Sometimes it's a more effective tool to just have a backup trustee step in for you than having somebody run around with the power of attorney and try and get control of your assets that way. Real estate in multiple jurisdictions. Okay, probate happens in two places. It happens wherever you are domiciled and wherever you own real property. So if you own real property in a bunch of different states, well, if you put it all into a trust, you've avoided probate in all of those different states. And probate fees on larger estates, well, Maryland has a progressive probate fee structure. So for smaller estates, the probate fees are fairly nominal, but once you get to big estates, they're they get quite pricey. So you can save on that. I'm going to talk a little bit about irrevocable trusts, not go too in depth, but there are a bunch of different categories, but there are a bunch of different ways you can categorize them, but I'll categorize it this way. Uh, you can set up trusts during your lifetime. We call that inter vivos because we lawyers just love throwing out Latin terms. Or they can be set up at your death under a will or a revocable trust. Those are called testamentary trusts. For inter vivos trusts, that's normally for estate tax planning or special needs planning. If it's special needs planning, it's normally a disabled beneficiary has come into a sum of money. They're receiving means tested benefits. That sum of money from a lawsuit or something like that is going to disqualify them from those benefits. So they need to make a trust for themselves and put that money into a trust so they can continue to qualify for their benefits. For the estate tax planning, that's when we're in the mega millions of dollars range. So it happens and we deal with it, but it's not something for an estate planning sort of 101 presentation. For the testamentary trust, this is the one that we run into more often because these are things that affect everyday people. If you leave assets to a beneficiary, well, if you leave it to them outright, it's exposed to their creditors. So if they're driving on the Beltway and they run a bus of school children off the road, well, those school children's parents can sue for all of their future earnings and come after whatever inheritance you've left them. But if it's in a trust, it has some extra protections. I don't want to overstate the spousal claims piece because inheritances already have some protection from claims of spouses, but trusts enhance those protections. Control on where assets ultimately pass. So you can help make sure that your family money stays in the family, continues on in the bloodline. This is really important for blended families in that scenario where you might want to benefit a spouse during their lifetime, but have it come back to your kids at the end of the day, or you just don't like your daughter-in-law or son-in-law, comes up. Special needs trust for a third party. So if I have a disabled child, for example, and I want to make sure when I pass away that I don't disqualify them from benefits, I would want to make sure that they're not getting their inheritance outright, that it's going into a special needs trust. And then for large estates, there are some potential estate tax benefits. So that's avoiding probate with trusts. I'm going to talk about avoiding probate with joint titling or beneficiary designations. For all this, I'm going to caveat it and say that do this with caution. This is something that it's very tempting to just kind of say, oh, well, I've got TODs, TODs on everything, so I don't really need a will. There are all sorts of ways that that can go awry. So joint titling, it does avoid probate, but it can have unintended consequences. It's very common for spouses, especially in a first marriage. But for example, let's say I put my oldest son as joint with me on my bank account, and then he gets sued. Well, now all of a sudden, that bank account is one of his assets that his creditors can get. Other tax considerations too for other assets. Beneficiary designations are necessary on retirement accounts and life insurance, but they should be part of the estate plan. We'll often give custom beneficiary designation advice when we do an estate plan to make sure that everything is flowing together. And it can be used on other assets too, but that's where I said be careful and make sure that you're, if you do have a plan in place, that you're doing everything in consultation with your attorney. All right, so how do I make an estate plan? Really three options: DIY, online forms, or go to an estate planning attorney. I understand that this is like going to the surgeon and asking whether it's a good idea to operate, but I'm going to tell you that DIY and online forms are an option. They can have unintended consequences. And we have seen forms that are actively harmful and worse than nothing. The problem is you just don't know what you don't know. They look good, and they're you look at it and you say, "Oh, that it all checks out," but you don't know what's missing. You don't know what important provisions are missing. You don't know um, what accidental contradictions are in there. We just had our first ChatGPT will that we're probating, and thank goodness everybody's getting along, and we're able to get some side agreements together. But if it went through as it was originally put together, it would have been a complete disaster. So, an estate planning attorney, they are going to have up-to-date forms that account for changes in the law. They can customize the documents for your circumstances and know what those customizations mean. And they also carry malpractice insurance. So if they screw up, they can be held accountable. All right, there's my hard sell. So, what do you expect with an estate planning attorney? What's the process like? From beginning to end. So, some attorneys do free consults. Often attorneys charge. I know at our practice will do like a quick kind of getting to know you call where we explain the process, 15 minutes or so, just so you're comfortable enough to come in for a consultation. That would be free. But if you're sitting down for a consultation, we'll charge you for it as part of the planning. If you choose not to move forward with doing the documents, we'll often request information prior to the meeting. Normally, it's filling out an intake form, and that's just for everybody's time's sake, so we can have an efficient first meeting. Cost and billing should be open and transparent. There's really two ways to bill, either on a flat fee basis. So after, oh, sorry about that. Somebody was rude enough to call. Um, so there can either be a flat fee basis. So at the end of the meeting, you just get a fee quote, or on an hourly basis. That's normally for more complex plans. Some attorneys just choose one or the other. Um, Most attorneys will have you sign an engagement letter, so outlining what the scope of the services are. And the fee itself is going to vary based on the firm and the experience level of the attorney. In terms of costs themselves, it does vary. It is all over the map. It is kind of a you get what you pay for business. I know our documents can start around 2,000, 2,500, and can be, three, four, $5,000 or more, depending on complexity. There are attorneys that are cheaper than us. There are attorneys that are far more expensive than us. Your mileage is going to vary on that. But no matter what, it should be absolutely transparent. I know when we have an engagement with a client, we send out our fee schedule beforehand so they can have an idea of the ranges that they're working with, and hopefully there's no sticker shock. Drafts and review. After we've met, we've gone through your situation, we've had that consultation, we've given you the fee quote, get drafts out to you. And oftentimes those drafts go in advance so you can look through it, you can get comfortable. Then the attorney should give you the option to review it together, to have your questions answered, and to make sure that you are comfortable with the documents as they are, that you can implement any changes that you want, that you can get any questions answered that you have. Signing the documents is the easy part. That's just a meeting to put pen to paper. Oftentimes that's 5-10 minutes. The question is, where do you store the documents? Really, three options for that. Sometimes, and this is our practice, some attorneys will hold on or will offer to hold on to the documents. Uh, some attorneys absolutely do not want to do that. That's more often with solo practitioners. They just don't want to have that liability. You can file it with the courthouse. So you can go to the Register of Wills. There's a $5 charge to put it on file in the county that you're domiciled in. And that's absolutely an option. or you can hold on to it yourself. Don't typically recommend holding on to the original yourself. If you lose it, there's a presumption that it was destroyed. Whereas if it's in the custody of somebody else, there's a way to get a copy probated. So typically recommend having it in other safe hands. And then the follow up. The follow up is really, really important. Um, Beneficiary designations, asset titling, if you do a revocable trust, making sure that you actually get the stuff into the revocable trust. If you have trusts for the kids, making sure that you've got the retirement accounts pointing correctly to the trusts for the kids, things of that nature. And then future follow up. How often? How is that handled? So uh, we typically do routine follow ups with clients every couple of years, and then clients will uh, get notifications on any big changes of the law based on just email blasts if there's a big topic that might affect them. But you should probably be taking your documents off the shelf every 3 to 5 years or so, not to say, oh my goodness, something needs to change, but just to make sure that everything still kind of says what you wanted to say, that all the people are still appropriate, things of that nature. How to find an estate planning attorney. First, referrals from trusted friends, family, and advisors. Go to online reviews from trusted sources and look for experience and specialization. So referrals are going to be the best place for that. And if you have a financial advisor or a CPA, those are oftentimes the go-to people. They're going to have people that they work with and trust. But friends and family are also great places to start. And the experience and specialization, can't say enough about that. Red flags, I'll sort of skip to the doesn't specialize area, uh, going off of that experience piece. This is a complex area of law. Um, and I'm not saying there aren't people who do multiple things and do them all well, because there are certainly exceptions to the rule, but I know that I could not practice this and family law and bankruptcy law all at the level I'm practicing this. So it's something that you really should look at somebody who does this practice. Shouldn't look at you should if it feels like a one size fits all, everybody's getting jammed into a certain mold, and you just feel like you're getting the same documents everyone else is, that should send up some signals. Not transparent on price after they've gotten an understanding on your situation. They don't respond to your questions or don't explain things or follow up. But most importantly, this is about fit. It's about, are you comfortable? People are generally pretty intuitive about this stuff. And if you don't have a good feeling about somebody, that's not the type of person you want to trust, because this is an intimate process. We're getting to know things about your finances, things about your family, things about you. And it's something that you really have to be comfortable sharing with somebody. All right. I'm going to go through a couple special considerations when you're going through estate planning. In general, pay attention to beneficiaries. So minor children, significant assets, complex designations, real property. Those are things that indicate you might need a will or a trust. So for example, I have a 18-year-old son, and on his one day after he turned 18, he was in here signing a medical directive and power of attorney. He didn't need to sign a will. He doesn't have complex assets. He didn't need, the full estate plan. He just, simple was good enough for him. But if you have accumulated some assets, if you have kids, that means you need to get some planning done. The Maryland inheritance tax. Okay. Maryland has a tax that is separate from the estate tax, It's not based on how many mega millions you're leaving behind. It's based on the relationship of the person you are leaving the assets to. If it's going up or down, so if it's going to parents, to kids, to grandkids, step kids count, step grandkids count, all that. If it's going to siblings, those are exempt from the tax. If it's going farther afield, so if it's going to nieces or nephews, if it's going to friends, if it's going to the siblings of a spouse, um, cousins, those are not exempt. If it's going to, boyfriend, girlfriend, not exempt. If it's going to a registered domestic partner, exempt. So that's a new work in the law that passed last or 2 terms ago, I think. Um, you can now register as domestic partners and be exempt from the 10% Maryland inheritance tax. That's separate from the estate tax, which is beyond the scope of this presentation, but that comes into play with large estates. So the Maryland estate tax exemption is currently $5 million per person. So a married couple can essentially pass $10 million estate tax free. The federal exemption number right now is 13.9 million, going up to 15 million next year. So a married couple will be able to pass 30 million tax free. It's not something most people worry about, but it's something some people worry about. Um, so it's if you do have that worry, please give me a call. Fiduciaries, right? Um, if you have an estate plan and you have uh, something that has changed in somebody's life, so parents are aging, siblings are becoming more mature, your kids are becoming more mature and might be ready to step into a role, that might be a reason to consider updating your documents again. Those are the big things that people should look at when they're looking at potentially updating their estate plan. Pets. Yeah, so pets are something we get a lot of questions about. There are a range of options. Pets fall into the tangible personal property category, which I find funny. It's always, funny to say because they're considered a part of your stuff, like, the jewelry and furniture. We normally recommend keeping it simple and we don't try and throw in extra complexity when we don't have to, but some people try to, or some people don't try to, some people uh, really need a more complex solution because of their situation. So we've done pet trusts before. Children. This is the biggest concern for most people. So it's the most critical thing many young families do in their documents. So you've got to consider the real life implications. There are things that when people come in and they have start listing off names and they've said something before about, well, my sister is not really good with money. They mentioned that, 3 minutes ago, and they just named their sister as the trustee for their kids. Well, let's bring that up again and talk through this so we consider the real life implications of what it means when this person is actually sitting in this role. When you've got guardians, do you name both spouses or just one? There's pros and cons to both. What happens if they're divorced at the time? Do you still want it to go just to your brother, or do you want it the guardianship to fall to the next person in line? And then, like I said, just like I did with my son, when your kids turn 18, consider having them sign powers of attorney and medical directives because there is nobody, they're adults at that point. You are not legally authorized to carry on their business anymore. Um, I remember when I was 19, 18, and on spring break in Florida, I got into a really bad car accident and ended up in the hospital down there. And my dad had a heck of a time getting access to information. And it was a pretty gnarly situation. And this wouldn't have solved all the problems, but it would have definitely helped make things a little bit easier. Another quirk in the law, when having your first child, this is for couples who have decided um, to did a will, then then got married, then had a kid, or sorry, then had a kid, then got married. That by law automatically revokes a will. So if you've fallen into that specific ordering of things, you think you have a valid will, but you need to redo your will. Just one of those weird things. Um, Also, you might want to split up who does the financial decisions for your kids and who does the parenting decisions. You can bifurcate those roles and have somebody be in the guardianship role and somebody be in the trustee role or the custodian of the uniform transfers to minors account role. Retirement accounts. Yeah, don't forget those old 401ks. Pay attention to beneficiary designations. I've said it a couple of times now. You want to really make sure that those are up to date. Same with old life insurance policies. We had a situation where somebody passed away and their ex-wife was the beneficiary of a significant life insurance policy, and that ex-wife was not the mother of the kids. And luckily it all worked out. You know, she ended up doing right by the kids, but it was potentially a pretty sticky situation. And these aren't things that update automatically with each new child. So, like your will is typically going to say descendants per stirpes or something like that, or as many shares as I have children. So it will normally automatically update as you have new children, but beneficiary designations don't typically do that. Organizing information, your digital assets, your passwords and access. Most of our lives are easy for us to get to with two-factor authentication, but hard for anyone else to. So it is helpful to lay out a roadmap for somebody of how to get to that important information, how to get into accounts and things like that. I have an open if dead file essentially that my dad and brother have access to if they ever need to, you know, or when they need to get to that information. Um, Debt, just very quickly, considerations there. So certain debt goes with you. Um, there's secured debt, so like a mortgage on a house or a loan against a car. That's enforceable against the asset itself. So if I pass away and I pass away owning a house with a mortgage on it, and my estate stops paying the mortgage and violates those terms, uh, there could be a foreclosure and the bank can go after the house itself. Unsecured debt is enforceable against the estate. So if I have a credit card, then they can come after my estate. They can't come after anybody else. They can't come after my beneficiaries. It's just against my estate and whatever assets are flowing through my estate. Joint debt. So if there's a loan that somebody else is joint on, they can typically come after the survivor. And then the one good news about student loan debt is it's discharged at death. So congratulations on that, I guess. And then business succession planning. The last piece I'll talk about is if you own a business, what happens when you pass? And you can consider a buy-sell agreement or an operating agreement. Just other, this is more of a niche thing. So if you have a situation where you have a business and you're doing your estate planning, make sure that your business succession planning is integrated into that conversation. Anyway, that's the presentation. Hopefully that gave you a little bit of an overview. Hopefully that was helpful. I'm going to go ahead and stop sharing now, and I think we're going to turn it over to the Q&A.
Christopher, thank you so much. That was super informative. We've got a lot of questions. I'm going to try to consolidate some of the thoughts so that we can get to as many of these as possible. A concern for a lot of people seems to be oversight. And you did mention that where wills are concerned, the Registrar of Wills oversees that process. But if trusts are private, what oversight mechanisms are in place for a trust? And then for both a will and a trust, if the trustee or the executor of the will disagrees with something in the document, are they bound to follow it?
Answer the second question first. Yes, they're bound to follow it. If so, in terms of oversight, um, the beneficiaries of a trust can sue essentially to enforce the terms of the trust. So if the trustee is not doing what they're supposed to, the beneficiaries have rights. They can go to the court and have the terms of the trust enforced. If a non-beneficiary says that there was undue influence and such and such sister came in and changed dad's trust at the last second and XYZ, they can also go to the court and sue under the same type of theory. So you can get the courts involved. It's just not a public document by its very nature.
So clarification question on that. If it's not a public document and you don't know you're a beneficiary, how would you learn that? Is the trustee bound to notify everyone who is a named beneficiary at the time the trust holder passes?
Yes, so there's under Maryland law, under the Maryland Trust Act, there's a notification period. I think it's 60 days or 90 days or something like that after they assume the office of trustee or after death. And it's different based on, I think there's two different windows. I need to check the act. I don't want to shoot from the hip there, but there's a discrete notification period. And if you're outside of that notification period and you haven't gotten notice, you can go to the trustee and say, what's going on? I'm due notice here. And if they still don't answer you, you can go to the court and attempt enforcement there.
Okay, thank you. Have more questions about wills and state of residence. So you mentioned that if you own property in multiple states, there's the possibility of probate in multiple states. Do you need a different will for each state?
Nope, one will is fine.
Okay. And in terms of safekeeping of the will, you had encouraged that the person whose will it is, that they not necessarily be the one to hold on to that original document. In my work, I've heard of instances of people keeping it in a bank safety deposit box or a lock safe, and then there's lots of trouble because nobody can access it. So, do you have any recommendations other than a trusted other person? Where is the best place to keep a will?
If you don't have a trusted other person, then I'd recommend filing it with the Register of Wills in your county.
Thank you. We have some questions. There's one here where says the parents do not have a will. They live in a condo in the person asking the question's name, and that person asking the questions, their name is on the checking savings account. Do the parents still need a will if they don't actually own those assets?
So the parents
live in an asset owned by someone else.
Yeah. Well, to the extent that parents have other assets, if they don't have any assets, then they wouldn't necessarily need a will. But if they have any other assets, then they might.
And then another question, if you have a trust, do you still need a will?
Great question. When we do trusts, we still prepare a will to go along with it, because even if we think we've gotten everything into bucket number 3, we might have missed something, or something might come in over the transom, whether it's a federal income tax refund or that refund check from a partial month of Comcast for $31.72 or something like that. So we do what's called a pour over will, which says take anything that would come into my estate and pour it over into my trust so that my trust is the one thing that controls everything.
And so more questions about state of residence. So if
Mhm.
you create a trust in a particular state, let's say Pennsylvania, and now you move to Maryland, do you need a new trust, or you just have to make sure you're updating the content of the trust?
Right. So once something's in a trust, we typically don't do a different trust. We'll amend and restate the trust if we do anything. Um, Sometimes there's no changes that need to be made because things are similar enough. If it's a state with kind of different underlying foundational law, so let's say you're coming from California, which is a community property state, over to Maryland, which isn't. Um, Things might be different enough where, yeah, we're gonna recommend amending your trust. Maryland to Pennsylvania, that maybe we don't necessarily need to do that. It's again going to depend on facts and circumstances.
Mhm. Can you talk a little bit more about individuals being named directly on assets? Like, what is the difference between tenants in the entirety or tenants with survivorship and tenants
Yeah,
in common?
got it. So those are the three ways that people can own property. Tenants in common means I own 50%, you own 50%. My 50% goes through my will, your 50% goes through your will. Joint tenants with the right of survivorship is last person standing. So if that's the first bucket that I was talking about, where if one of us passes away, it goes to the other one. Tenants by the entireties is joint tenants with the right of survivorship, but it's just for married couples who have purchased that property as a married couple. And the big difference is it comes with certain other protections. It's protected from the claims of the individual creditors of that couple. So if one of them gets sued, then they can't come after the house essentially.
Perfect. And so now we've got some questions about the medical authorization. So if someone has an adult child who lives out of state, what are some
Mhm.
considerations that they should be thinking about?
Yep, you should. It's the same considerations that you'd think about in the state of Maryland, but you'd be using the state of residence of that adult child typically. Um, it might depend on how adult that adult child is, their age and their nexus to Maryland. If they're coming back quite often and they're 22 years old and they might end up back in Maryland, that's something where we might still feel comfortable seeing them. But if they're 27 years old and have planted roots, yeah, go ahead and find an attorney in that state, and they should be getting a medical directive and power of attorney done there.
Terrific. And if someone wants to leave their assets to charity, either through a will, a bequest, or a beneficiary designation, how does that differ from leaving assets to an individual or a family member? What do they need to be mindful of?
Sure. Well, leaving assets to charity is a fantastic thing to do. It's really, in a lot of ways, not different than leaving it to any other beneficiary. There are some assets that are better to leave to charities than others. So, for example, retirement accounts are a great asset to leave to charities. Um, if I've got a retirement account. I have never paid tax on that money. When I take money out of that retirement account, I've got to pay tax on it. Same with my beneficiaries. Who doesn't have to pay tax are charities. So that dollar is a full dollar to a charity. It is not a dollar to my kids. So updating my beneficiary forms to name the University of Maryland System Foundation, or I'm not sure what the name of it's called. I apologize, but uh, that's a fantastic way to allocate the charitable dollars.
So what I would add to that, because there is a lot of confusion over charities' names and, within a university system or even
Mhm.
humanitarian or animal rights organizations that might have local chapters and national chapters. Um, would you encourage that individuals contact those organizations to find their taxpayer ID so that they
Yes.
can be precise in naming the recipient so that they don't unintentionally leave money to what they think is the right organization and it turns out it's not.
Absolutely. You should absolutely do that because there are a lot of things that sound very similar and are very different.
So now we have some questions about, again, more about the health directives. These pertain to vulnerable individuals. So I guess one person would like a little bit more guidance on what counts as disabled.
So when it comes to medical decisions, that's going to be a medical determination. If the doctor that you are being treated by does not believe that you are able to make your own healthcare decisions, then that's when they're going to listen to your healthcare agent over you. When it comes to a power of attorney, we often set it up so it is technically not springing into effect upon your disability, so we don't even have to answer that question, which does sound a little scary, but it also means that you don't have to have your personal business out there, because otherwise it is getting physicians to sign off saying that this person is not able to make their own decisions. It would require two physicians otherwise, and it's kind of burdensome to do. A, it might be difficult to get somebody to a physician in the first place. B, do you really want letters about your disability circulating to Bank of America and BG&E and anybody that your agent needs to talk to? So oftentimes we just say, hey, this is a person that I put trust and confidence in. I trust them with all these powers. I'm going to trust them to know when it's a good idea to use these powers.
Terrific. We have about 2 minutes left, so I'm trying to make sure that I'm hitting on topics that we haven't covered yet from the Q&A. I'm scanning quickly here. I think you answered this, but and I think this question was posed before you gave the clarification, but we'll revisit it. Is someone asked if godchildren are exempt from the Maryland inheritance tax? And I presume that would depend on what their biological relationship is.
It's all depending on your biological relationship. Yes.
Can you give a rough definition of what is a large estate?
So it's going to depend on the context there. When I'm talking about large estates for um, uh, whether it makes sense to implement estate tax planning, we're talking about the mega millions of dollars. If it's whether to have a revocable trust versus a will, it's a lower threshold. It's going to be, the probate fees probably makes sense to avoid. Maybe around $1 million. That's probably about the break even point. And there might be other reasons you want to skip probate, regardless of that.
Terrific. Well, we're right at 1 o'clock. Can we quickly put Christopher's contact information back up on the slide, back up on the screen while we say our goodbyes?
Or
And I would also just jump in and say, I know there were a lot of questions in here. Again, I'm assuming that Chris would be willing to, follow up and hear from you all if you have other questions that weren't addressed. And also, please come back Wednesday, Thursday, and Friday. There'll be more questions to ask our professionals for opinions about some of this. So that was packed full of information. And Janine, I'm glad we got your mute button figured out.
Yeah, me
You did an
too.
excellent job there moderating the questions because there was a lot flying in fast and furiously.
Mhm.
Chris, you did a wonderful job of explaining a very complex topic and in a way that I thought was really easy to understand. And I think it really just goes back to the need to engage in this process. It can seem overwhelming, but once you take those first few steps and get your plans in place, it brings incredible peace of mind. So would really urge everybody out there to, take the plunge and get your plans in place and make sure that your wishes are taken care of, because that's really what it's all about. So thank everyone so much for joining us. Please come back tomorrow. And again, we'll be sending out the recordings and a short survey early next week. So thank you all so much and enjoy the rest of your day.
Thank you.